Federal Judge Allison Goddard, welcome to the show.
Thank you, Oliver.
You are a federal judge. Do you think AI will replace judges? Can you tell us what use cases you're actually using these AI tools for?
Sure. When it comes time to write the order, I can upload the briefs into an AI tool and ask it to summarize the parties' positions for me. I get concerned about going outside the record. I get concerned about bias in the LLM.
Do you think lawyers will get sanctioned in the future for not picking up on opposing counsel's miscitations? You are anti-standing order on AI, and that's a point of common ground among us. So can you tell me your rationale for that? Federal Judge Allison Goddard, welcome to the show.
Thank you, Oliver. It's great to have this conversation with you. I appreciate you asking me.
Pleasure having you here. So Judge Allison Goddard has a very interesting background. She's been a litigator for 20 plus years, having worked at Cooley and started her own law firm before joining the bench in 2019 as a federal judge in the Southern District of California. But what really stuck out to me is Judge Goddard's non-traditional path to law school and to the bench, which included working as a receptionist, then going to law school, then starting her own firm after practicing at Cooley. So Judge Goddard, this non-traditional path, tell us how this has impacted your rise to the bench.
Sure. And I'll have to say my pre-law school job titles include receptionist, tariff manager at a local exchange company, contract specialist. I think I did a couple of different things, and I realized that maybe I should just go to law school and be one of them because I was working with a lot of lawyers. But I think I learned a lot along the way. Oh, don't forget cocktail waitress. I did that too back when that was
I missed
the term,
that one.
right? But I think that non-traditional path to law school, it made me really grateful for the opportunity to study law and be so engaged in a profession where your brain is the product, really. I remember being so amazed when I first started working at Cooley. I was known as a timekeeper, and my work was the product. And I got so much more respect than I had done in my previous jobs where I was kind of like a drag on the system or a drag on the bottom line. So I learned a lot in all those jobs along the way. And it also, I think it gives you a strong sense of, as a lawyer, that you're representing people, even when you represent a corporation, there's the people behind the corporation. And having that experience, having worked in various positions, I felt like made me ready to kind of engage with people as a lawyer and provide and recognize my role as counselor.
So the shift from litigator to the bench, what prompted the transition, the fame or the money?
I was definitely not the money. By the way, when I told my kids that I was going to become a judge, I overheard my daughter say to my son, well, when mom gets her new job as a judge and she starts making more money, maybe we can go back to Hawaii or something like that. And I was like, oh, honey, that's not how this works. And I said, I'm not going to be making more money. And she said, well, then why would you do that? But I mean, I think obviously the opportunity to serve the public in a position like being on the court, to be part of the judicial system, which I had so long revered, was really, it's just an honor beyond all honors. But also I was tired as a litigator. It was a lot of work and it could be exhausting. And so that's what made me kind of look to see if I could get on the bench. And then getting on the bench is really a matter of kind of serendipity. You have to have the right luck come your way at the right time. And so you have to have the credentials, the background to be eligible for it, but then it takes a lot of luck on top of that. So.
And we're going to jump into, I think, both of our favorite topics these days, which is AI shortly. But one other question about the judiciary generally. I've heard you talk about this, and you've talked about it in the context of your immigration cases and deportation cases. And that is, when you look at the result that a judge issues, it's not always what the judge wants. They have to follow the law and apply the law. But to the general public, they'll often just see the final result and say, hey, that judge messed up. I don't like what that judge did. But the reality is it's more nuanced than that. Can you explain that dynamic as a judge where you don't just get to decide whatever you want in the outcome? There are other factors to consider. Can you explain that phenomenon?
Yeah, if you want to think about it like this, I'm on a one-lane road and I can only go in one direction. And it's like there's construction and there's barriers on both sides of the road because I'm at the lowest level of the courts. I'm at the trial court. So I'm not making law in my position. I'm following the law that other people set. Now, once you get onto like the Ninth Circuit or a circuit court, now you're on like a 2-lane highway. You can kind of shift between lanes a little bit, or I should say 2 lanes going in one direction. You can move, you can shift lanes, you can change your position. They can actually make law. And then the Supreme Court, there's no barriers. They could drive all over the road. That's okay. And so, but in my position, I don't get to choose sometimes. Sometimes I have to, it's not, it happens more than, but you get used to it. It happens. You have to make a decision that you wouldn't necessarily personally agree with. But when I swore an oath to the Constitution, I swore to adhere to those legal principles of stare decisis, of following the law of the appellate courts and not making new law. I do have a lot of discretion in what I do. So I do a lot of discovery. And so in some of the cases I do, I can make a call based on what I see on the facts before me. But there's a lot of cases where I don't really have any discretion at all, and I just have to apply the law as it stands, whether I agree with it or not. It's important that judges do that. I think it makes our judicial system reliable, it makes it predictable, and also it makes it objective. It lends a necessary air of objectivity to it, so that we hear a lot now, and the judges get a lot more press, I think, than they did before. You hear about Obama judges or Biden judges or Trump judges, and as if that shades what judges decide. But at the trial court level, we really don't have. You just have to apply the law as it sits. So that's my lane. There's big concrete barriers on either side, and I can only go one way.
And you talked about looking at past precedent and just following what past precedent is and predicting the next thing. That kind of leads us into artificial intelligence. So my question for you is, you are a federal judge. Do you think AI will replace judges? I don't. And trust me, I've used a lot of the tools, and there's a lot they can do to help judges, but I don't think they can replace judges, even just from a technological perspective. But I also don't think our society is ready for judges to be replaced. So I think 2 things have to converge before AI would even come close to replacing humans as judges. 1 is the technology has to improve, and 2, society has to be ready for that. I do think there are ways that we can incorporate AI to help us be better judges. And I think we need to show as judges, in order to elevate public confidence in the system, that we don't have to be experts in the technology, but we need to be aware of it and open to it. Relatedly, do you think AI could replace lawyers anytime soon? I think it's the same answer. I do think it can step in and do quite a bit. So for example, if you're a pro se litigant, I think it can do a lot to help you in the case. I still think you'd rather have a lawyer if you could, right? And I think that's a good way to look at it. We did one of the experiments I ran with our librarians in early days, and probably like a year ago, a year and a half ago. We see a lot of pro se cases, both by prisoners who don't have access to AI tools. So that's just one category. AI is not going to help them anytime soon. But we also have a lot of pro se cases and like excessive force cases where someone is arrested and they challenge that the police violated their constitutional rights in the course of that arrest. And so those can be challenging cases for us as judges. We have pro se law clerks to help us with them, help us kind of sift through like what's actually being alleged. We took an excessive force complaint by a pro se litigant. We uploaded it into an AI tool. We asked it to draft, and we uploaded the motion to dismiss that was filed by the public agency. Then we asked the AI tool to draft an opposition to the motion to dismiss. And the first pass was, and then we told it, look, we need you to pose a motion to dismiss. We need to actually highlight the specific allegations in the complaint that state a factual basis for the claim. And on second pass, the AI tool did an excellent job. The pro se law clerk said, I would love every day to read a brief like this from pro se litigants. But of course, 25% of the cases in it were hallucinated. Mm-hmm. But the pro se law clerk said, pretty common. I don't care. I'm really familiar with this law. I can tell, and I can put it through a tool to tell that, and it'll tell me that those cases were hallucinated, and I can disregard them. So I think it can be a really effective way. But I think if you ask yourself, okay, so that would help, that'd be better than someone who wasn't a lawyer trying to draft briefs on their own.
if that person could get a lawyer, don't you think they'd still get a lawyer? 100%. So I don't think it's ready to replace lawyers. I do think it can make things a little bit easier for pro se litigants. And the courts are very briefs.
Yeah. And I've heard we held a public event with Judge Deal, the DC Court of Appeals, and he said a similar sentiment where he actually prefers pro se litigants to use AI because at least the arguments are more coherent. Yes, the cases are likely hallucinated, but it's more so understanding the claims and the coherence of them. So that is, of course, considered vis-a-vis an influx of more filings by pro se litigants. I've heard stories from both lawyers and courts saying that pro se litigants are now filing motion after motion, and the filings that they do file are often 10x the amount of length compared to what they used to be. How do you balance the benefits of pro se litigants using AI versus those potential drawbacks on court resources?
Well, I just haven't seen that in our court. I think there are one of the things that you learn after being a judge for a while is there's a lot of pro se litigants who don't flood the system, right? They call it, they're just regular litigants 9 times out of 10, maybe 99 times out of 100. And then you'll have that one. And they don't, and you try and meet with them, you try and explain how it works, and they just don't get it. And they're just but they'll do that anyway, because they're kind of perseverating over whatever the issue is in the case. But we have ways of addressing that. So in our court, if you're pro se, you don't get automatic access for electronic filing. And if you're abusing your privileges by filing meritless motion after meritless motion, we can say you don't get that. You have to come to the clerk's office and file in person every time. And that can be a way to kind of get them to calm down a little bit on their filings. And then as far as filing new complaints, there's a filing fee. Now they can file multiple IFP motions, but that's to represent yourself without paying the fee in form of papyrus. But I haven't seen those types of serial filings in court like you might expect. That doesn't mean they're not going to come, and when they come, we'll figure out a way to address them. But right now, I haven't been aware of this for 2 years. I haven't seen any of the onslaught that people initially predicted when we started.
Mm-hmm. Yeah, that's an interesting perspective. And you've previously said that you hope lawyers are using AI these days. Do you think we're at a point where lawyers are practicing law unethically by not using AI?
Well, I think that's kind of a hard call because you can practice law competently without using AI. That can be done. You can be a proficient lawyer and do that. But are you doing it in the best way for your client? Right? And a lot of it also depends on the kind of law. Some law is more complex than others. And there may not be the fact that AI can help you write a better brief doesn't mean you're not going to be a competent lawyer. But I do think, and I can't remember the quote and I don't know who said it, but the lawyers who figure out how to use AI are going to replace the lawyers who don't know how to use it, right? I mean, it's not that AI is going to replace lawyers, but the lawyers who know how to use it are going to have such a leg up. And I think the challenge is, it's really, as someone who was as a sole practitioner myself for a while, or in a small law firm, you often don't have time to just go learn about new technology. And it's going to take the lawyers at smaller firms longer to realize that there's an advantage to them to learn. It's not that complicated, and they can find a way to integrate in their practice. But the big firms, I think, are doing a really good job because their corporate clients are asking them, how are you doing this? How are you incorporating it? Is this going to this should be making my bill cheaper, right? The big firms are doing a really good job, but it's going to take a long time to get down to those smaller law firms.
Mm-hmm. Yeah, it makes sense. And just thinking it out, that theory that it may one day become unethical to not use AI, how do you think that would actually manifest in terms of enforcement? One thing that I would think of is if you do a big document review and you submit for attorney's fees and you show that you billed all these hours manually without AI, maybe the court could say, hey, we're not giving those attorney's fees. And by the way, that's unethical. Is that the way it would manifest, or how do you think this would actually convert to a world where not using AI is unethical?
I think that's going to be in the hands of the Bar Association. So, for example, I think you're going to need to, you'll see a bar rule, either the ABA model rules or maybe a California rule that says the duty of competence extends to knowing about technology, including artificial intelligence technologies, or a formal opinion from the Bar Association that says, from the State Bar, that says not knowing about this is incompetence. I think the time when judges could reduce attorneys' fees because lawyers aren't using the technology available to them, that could happen without any sort of comment on ethics, right? And I think that if I were doing plaintiff's work, for example, in complex litigation, and I were trying to get the judge to appoint me to be lead counsel, I would let the judge know that we use the best technologies available, and that it's going to mean that we can handle the case more efficiently, be fewer billable hours, and that results in better legal representation. I would certainly tout that. Firms market themselves all the time when they're trying to be liaison counsel or lead counsel. I think that's important. And I think a judge may find if you're not using, if you were still researching using books and you didn't have any legal database subscription, and then you ask the judge to pay for all the time that you took, it's probably at least 1.5 times more time. I think that the judge would say, I'm not doing that. That's not the standard of practice now. So when AI becomes the standard of practice, I think judges will be expecting people to use it.
And speaking of judges using AI, you're on record saying you've turned to Claude every day, although we just had a discussion, you and I, before this, that you actually broke up with Claude. Can you tell us about how you've navigated this breakup in a relationship and who you moved on to since?
So I'm not endorsing any particular product, and I still love Claude, and I think we'll be in touch over the years. We haven't lost touch. It wasn't that bad of a breakup, but so I'm not endorsing any particular product, but I am just being straightforward about what I'm using. And I'm a bit agnostic, but Perplexity is I've been kind of playing around with Perplexity because it allows me to run prompts against multiple LLMs. So I can run it against Claude, ChatGPT. And also it has an arrangement with the government where if I'm using it from a government website, I have a higher level of privacy settings in other words, like whether or not they use my inputs and outputs to train the LLM. Perplexity has reached an agreement with the government for government users to kind of keep those privacy settings at the highest level. So that's why I've been shifting a little bit away from Claude. But I can still see other people through Perplexity.
Mm-hmm. Yeah. That's good to know. What other AI tools are you using? Or is it just Perplexity in your chambers?
No, I use a lot of different tools. We are in a trial right now in the Ninth Circuit. So I have access to Westlaw AI tools, which I use. I have access to Lexis Protégé, which I use. I've played around with Learn a Hand. I played around with Merlin Alchemy. We played around with VLex for a little bit. In the Ninth Circuit, we had a trial period with that. And then, Gemini, obviously, if I'm on a Google browser, it's funny, you first start with, you say, I don't know if I want AI search. And then now, it takes about 3 searches, and then you're like, this is so much better. So, right? Mm-hmm. I mean, it's been easy to convert me. I don't know if I'm an easy mark or if the product is so good, we are waiting to see if they might turn on Copilot for the judiciary. We just don't know. The judiciary is being really cautious about wholesale turning on certain tools, which I can appreciate, but I'm pushing for us to make these tools ubiquitous too within the judiciary.
Yes. And so those are the tools you use, and we talked about a very interesting use case in your Social Security prior orders. Can you tell us what use cases you're actually using these AI tools for?
Sure. And this is a good time for me to say clearly on the record that I'm not speaking for the judiciary. I'm only speaking for myself here in any information I give about the tools I use. But there's a lot of different ways that I use them for helping draft orders. Where you have a collection of the same order that you write over and over again. For me, that's Social Security appeals. I've created a collection of my own Social Security orders. I've created it. I've actually got one in NotebookLM. I've got one in CoCounsel. I've got one in a Lexis Vault for Protégé. So I've got multiple collections that I can use to prompt against. And I can share those with my clerks. So my clerks have access to this too, that they can use it when they're doing their work. And Social Security orders are really fact specific, but they're hard to identify. Sometimes you need to search them both by issue, which is you might have several opinions on orders on one issue, and sometimes you want to search them by facts, and that just lends itself really well to prompting in an AI collection using AI in a collection of documents. So I can go prompt against my set of Social Security orders. I can ask it to identify all the orders on this where I've touched on this particular issue, so I can pull up and have it draft a legal standard. And that's drafting the legal standard based on my own set of documents. So I'm not worried about plagiarism. I'm also not worried about inaccuracies. And I would run it always through some AI tool to check it before it became a final order anyway, just to make sure no hallucinations got in there. So I can run it by that, or I can do a search. Like I might have, there's one case I did where a guy lived in his van for 3 months in San Francisco. And that case I'll remember kind of parts of that case, but I can't remember the guy's name. So I just ask it, which is the case where the guy lived in his van for 3 months? It pops right up. And it gives me pinpoint sites to what I'm looking for, which is really important because I can pull up the original document right there. And if I don't want to have it draft the legal standard for me, I can just cut and paste and chunk the legal standard from that document right into my document. And that is a huge time saver. It's a really big time saver. It also gives me a sense when I'm drafting a new order, am I being internally consistent with the way I've approached the law? We talked a little bit about my lane. Well, it doesn't really look very good if in my one lane I stay within the concrete barriers, but I'm swerving all the time, right? I want to make sure that I feel like, the Social Security Administration is appealing time and time again. Do they feel like they're getting predictable, consistent orders from me? And that's just another way to make sure that I'm building my own body of work that is internally consistent.
Yeah, that sounds like a very valuable time-saving use case. How much time do you think it saves you?
Oh boy, I don't know how I would measure it. One of the ways I'll tell you, it makes a huge difference. You can use it to draft parts of an order. So one of the ways I think that saves me a lot of time, I would say probably it takes me like 5% of the time it would before. I don't know why it would. Maybe I'm calling myself out for this, but one of the things you put in an order is you summarize the parties' arguments. And one of the reasons why you summarize the parties' arguments is to make sure you've addressed them all, right? And so I will use it the first thing I do when I get a new motion in and it's fully briefed, I usually read the reply first, and then I'll read the opposition and then the motion. I go backwards in time. And because I feel like the replies really pulls out the biggest issues. And so I'll go backwards through that. And then I'll think about where I want to go. But when it comes time to write the order, I can upload the briefs into an AI tool and ask it to summarize the parties' positions for me. That does a couple of things. One, I've already read the briefs, so it's not, there's a human check on that summarization. I'm going to read the briefs. I probably end up reading like 4 or 5 times before I finish the order because I go back and forth to different parts. But I can have it summarize the parties' arguments. And it's really hard to summarize the parties' arguments without just like doing block quotes, right? And so you're trying to think of a different way to say what they said, but kind of say what they said. Let this do it for you. It does it so fast, right? And so I use that all the time in orders. It's really helpful. It's like a totally souped up thesaurus. So if you're looking for a phrase or even an analogy, you can just describe the situation and say, can you think of some analogies for me? And some of them are terrible, but some of them are really good, right?
Some of them are really cringe. I've used them before.
Yeah.
If you try to ask AI for jokes or anything, I was trying to look up some for this podcast. They're terrible.
Yeah.
So,
yeah. So those are, and then obviously for non-judicial work, like if I've got a presentation, have you ever done this? Have you ever just said like, here's the situation, I'm training judges on AI. Can you draft a PowerPoint for me that would identify like all the things you want judges to know and really give it not that much direction? I didn't use the PowerPoint for this, but it created a full PowerPoint file. It was the graphics on the slides were good. And what I did was I took that PowerPoint and I bumped it up against my own. And I just looked to make sure, was there anything I was missing in my own? And there were some things I picked up from it that I really hadn't thought of. And that to me, if you can use it to help you think of the things you hadn't really thought of, and I often don't have a partner who I can bump ideas off of. And that it's really nice to have that. It's really helpful.
Fascinating use case that I think a lot of other judges could definitely use and pick up on. So shifting gears a little bit, we're staying with AI in the judiciary, of course, but moving more so from using tools for summarization and preliminary preparation. I know you've also used AI for oral argument prep and question generation. But there have actually now been judges who have used AI as an interpretive tool. Judge Kevin Newsom in the 11th Circuit Court of Appeals, in two cases, DeLeon and Snell, pretty at length extrapolated on the ability to use large language models to interpret the original meaning of provisions in statutes, like physically restrained in a criminal case. Judge Deal of the DC Court of Appeals also used ChatGPT to answer a sufficiency question in a real case, and they cited ChatGPT as the source. What are your thoughts on moving from just using these tools for preliminary summarizations and prep to actually using it as a full-blown interpretive tool?
So I'm much more comfortable with the way I use it. I wouldn't use it as an interpretive tool. There's a couple of issues. First of all, I applaud those judges for just showing a curiosity and an interest in it. I think that's really good. But I get concerned about going outside the record. I get concerned about bias in the LLM. If you ask the sources that an LLM draws on, we don't know what they are. Some of them are scientific journals. Some of them might be articles in a newspaper. Some of them might be Reddit posts, I guess. I mean, I don't know all the things that go into that. So if you're asking for the meaning of a slang term, is there any way that an LLM is going to be able to tell you that? I mean, you don't, or if you ask it for the meaning of let's say a term of art in a medical term of art, is it drawing on those medical journals? We just don't know. And so I think you really need for something like the meaning of a term where that meaning has where it's going to have some legal significance. I think that's something you should let the parties come to you and say, this is what we think it means and these are our sources. And then as a judge, you decide between those things. But I'm concerned about going outside the record. And to me, I just think there's so many other easy, responsible ways to use AI in judging without going to that part. So it's not something I would do, but it's also not something I'm often called to do.
Yeah, I think very fair points. And I think the extra record evidence is a huge concern because a lot of these chatbots now automatically pull in the internet without you even noticing. So to get live information about parties and terms when those parties and terms could literally be in the news, and that's now integrated into your case. So that's definitely a big concern, and many others that we could go into depth on, but we don't have time today. Perhaps in the future.
The other good thing you can do, though, let's say that if I want to describe a complicated patent concept, right? And I have all the parties' briefs, and I'm writing the order, and the issue is VoLTE, which is voice over LTE, which is how your phone can let you make a call and surf the internet at the same time without the person on the call knowing that you're actually just surfing the internet or playing a game. But that if I've read the parties' briefs, now I'm drafting the order, and I want to describe what that means, I can ask it, give me a summary, describe the concept of VoLTE. I can even upload the parties' briefs, or I can give it a technical paper, and I can ask it at an 8th grade level or at a 12th grade level. And then I can read that summary, and it can be my first draft of how I put that in how I describe the technology in my order, which is much faster. But I also can back that up with what I know from the parties. So that's not me making a interpretation of a legal term that's at issue in the litigation. That's just me making my order, making it more efficient for me to draft my order describing that concept. That's a great way to use it too.
Yeah, definitely. And we talked about some of the responsible uses, but there's also now been a few irresponsible uses of AI on the judiciary. Two of the big ones in high profile from summer of 2025 include Judge Wingate down in the Southern District of Mississippi. He issued an order in a high profile case involving DEI in which he included fake citations, fake quotes, fake citations to the statute itself, incorporated multiple declarations and evidence that were not even in the record. And then in the District of New Jersey, Judge Niels, in a high profile biopharma securities case, actually included fake quotes and misstated the holdings in multiple cases. They were both then the subject of an inquiry from the U.S. Senate Judiciary Committee Chairman Chuck Grassley, and both of them ultimately took a little bit of responsibility, but also blamed a law clerk and a law school intern, respectively. Judge Goddard, what is your thoughts on this whole saga that has played out in these two cases?
Well, I can't speak to those two specific cases, but what I can say is, as a judge, one of the things that I've recognized is that I have to have a conversation with my clerks and any law school externs who work for me about, are you using AI? And so I have internal chambers guidelines It requires them that we give to them when they start their externship or their clerkship. It requires them to get my permission to use AI tools in their work so that I guarantee we're having a conversation. Because here's the thing, they grew up writing using AI tools. Like if they're getting out of law school, even like in the next year or so, they probably had ChatGPT towards the end of their high school career, but they definitely had it in college. And they may think it's just the most normal thing ever. They may think it's as normal as using Microsoft Word. And you don't want to learn from, like I always used to say when I was a lawyer, I hope my mistakes aren't number one, identifiable. And then if they are identifiable, I hope they're not quantifiable, right? You don't want them to learn the hard way. And that can affect your credibility and the judicial system's credibility as a whole. So what we've built into my chamber's rules, which I have shared to many, many members of the federal judiciary as we teach them about AI, is have the conversation with your law clerks and your externs. It's your responsibility. The buck stops with you. You're the judge. And make sure you understand what they're doing. And if you're not comfortable with it, then tell them they can't do it. And they'll have to find a different way. But if you're not comfortable with it, maybe ask them to show you how they're doing it. And maybe that'll help you learn a little bit about Gen AI, because it's hard for me to imagine. I can't think of a time when I showed someone how it works where they weren't like, okay, I want to try this out more on my own. And then the other thing we do is every order, before it goes out, we run it through a tool. There's a few different ones available at our disposal to look to make sure that there are no hallucinated citations or case law, because a lot of times if you pick up anything from the lawyers, it could be a hallucination. And I have definitely seen that there's some cases where the opposing counsel does not pick it up.
I saw a recent case in which this was in the District of Minnesota, I believe, where the judge actually called out opposing counsel for not picking up on those AI hallucinations. Do you think lawyers will get sanctioned in the future for not picking up on opposing counsel's miscitations? So a little ironic twist.
Yeah, I mean, I don't know if they'll get monetary sanctions because I don't know they didn't file anything affirmatively in the court. But I would think that being mentioned like that in a judicial order is kind of a form of sanctions in and of itself. It's not a good look, right?
Yeah.
And I think that lawyers should, as a practice, do the same thing I do, which is run their brief through an AI tool before they file it. But then I think opposing counsel, if you're wise, you would do the same thing. Take the brief that gets filed by the other party. There's lots of great tools that can actually help you kickstart your research, where you upload it and it gives you a report about the law they were missing. And that can tell you a lot too. But beyond, all their cites can be real, but if their quotes are out of context, or if there's other case law that they might have that's just not in there, but it's really relevant, that alone, that's a pretty good tell. And you can use a tool to tell you that from the start. That's much faster than just trying to research on your own and realizing they were missing the key cases.
Definitely. And so many great tools out there. Literally just hyperlinks the cases, pull them up, you click on them, and then you see if they exist or not. And you have it all right there, rather than having to do it manually. So back to the judges that misused AI. They, of course, got public ridicule, a lot of scrutiny. What mechanisms are there available to actually punish federal judges more generally? Aside, impeachment's obviously one of the most extreme, but what else is out there? What mechanisms to stop future instances of this?
So they don't give me access to the controls to discipline anyone because I'm too low down on the chain. But I think that, it's not most judges, I think that being called, getting letters from the Senate, having multiple articles published is pretty good incentive for judges to be careful. And I wouldn't expect this to see, if you notice, there's been these two issues with judges, but there hasn't been a proliferation of hallucinations in judicial orders. We thought MATA would make lawyers smarter about this, right? But there's been a full proliferation of hallucinations by lawyers at big law firms, at smaller law firms. And I think that demonstrates that it's not, we shouldn't expect it to be as big of a problem in the judiciary as it is for lawyers, although we should hold the judiciary to higher standards. So this is as it should be, right? It seems more like an anomaly than a problem.
Let me ask you this hypothetical, running off that. So, of course, we've seen a huge proliferation, some 550 plus cases of lawyers filing hallucinated citations, could be cites, could be fake quotes and authorities. And of course, we have judges supported by law clerks. Many of them can be younger, right out of law school. So they are inexperienced, and lawyers are lawyers. So it's already proliferating among lawyers. In those two instances where the judges filed orders with hallucinated cases, they blamed a law school intern and a law school clerk. So they obviously have some degree of influence, and that's kind of how it works in many chambers. And in my hypothetical is almost done. And in those two cases, it was actually the defense counsel who caught those citation errors. It was not the clerks, it was not the judge, it was not the plaintiff who won the case. It was these parties who lost, and they only saw them because they were appealing. Imagine how many other cases where pro se litigants lose and don't actually check cites, or a party loses and doesn't appeal. So is this really a matter of not proliferating in the judiciary, or it's just not getting checked, and there could be a lot more? Do you have any thoughts on that?
Well, I mean, I can't prove a negative, but I'd like to think that my theory is, I am known to be a little bit Pollyannish, but I like my theory better than yours.
That's fair. I'll give that to you. So we're now going to shift to talk about AI disclosures and certification requirements. You are anti-standing order on AI, and that's a point of common ground among us. So can you tell me your rationale for that?
Yeah, we used to draw this when I first started training judges in the federal judiciary on AI. I would include a Venn diagram that I created of the lawyers who actually read your standing orders and lawyers who, don't check their, lawyers who submit hallucinations and briefs. And the Venn diagram had no overlap, right? I don't know that I was 100% right on that, because I think what we've seen from some of these hallucinations is lawyers who read the standing orders are just not supervising the lawyers who are working for them very well, right? But I still think that standing orders are not the way to go. I mean, number one, judges don't know how to define AI. So what does it mean in your standing order? And lawyers take what judges say really seriously. So if a judge says you can't do this, then there are many lawyers who will not do that. So if you say you can't use AI, they may be concerned about using Microsoft Word to draft their briefs. And they should be, because Microsoft Word has elements of AI in it. It does, next word prediction, for example, spell check. And some lawyers are going to say, I just don't feel comfortable because I don't think that's, and you don't want them to be so paralyzed by that type of restriction. Also, it makes it look like you may not understand the technology at hand. Even if you say Gen AI, I've seen judges struggle to try and say effectively, you can use Gen AI tools by Westlaw and Lexis, but you can't use open source Gen AI tools. But they don't really know how to explain that or explain the difference. They're trying not to endorse a product. I've also seen standing orders that say you can use whatever you want, but if you use any form of Gen AI or AI, you have to state on your pleading that you used unverified sources. Well, how many corporate lawyers are going to feel comfortable with the brief they file with the court, that their outside counsel files with the court on their behalf, with a big used unverified sources to draft this brief? It's not really that's not how you want to lead off with the court. And so I think that's really problematic. And I think the worst part about it is it can chill lawyers from actually trying out this technology. So I don't like that it tends to show a lack of understanding from judges about how ubiquitous this technology is becoming and how it can be used responsibly. And I think it could stop some lawyers from actually using it. And I don't think that that's progress. So that's why I don't like standing orders. I really don't. I try and be as persuasive as I can with colleagues that that's not the right way to handle it.
What is the value add of a standing order? Does it add extra sanctions value? We already have Rule 11. What is the rationale?
I mean, I think it's the same thing as if you have an ESI protocol that is signed by the judge as an order. It's that one extra step if you need to go to the sanctions route. But honestly, I just don't see the benefit of it. I don't see the benefit of disclosure, like requiring disclosure, because I think it becomes that you have to disclose in almost every case, right? And I don't see the benefit of any sort of a prohibition on it either, because I just think that we can't impede progress in the law.
Mm-hmm. Yeah. Definitely. Definitely. So we're going to close out. And this has been absolutely fascinating. I've learned a lot myself, and I know those who are listening will as well. So what is your closing message to both lawyers who are using AI and judges who are using AI?
We're lagging as a profession in continuing education so that people have access to ways to learn how to use AI responsibly. But I would say the more you lean into it. So that means you can go on YouTube and look up videos on how you could use AI responsibly. You can listen to podcasts. I love listening to Hard Fork. I learn it's not a legal podcast, but it does talk a lot about how you can use AI responsibly, but also kind of gives you a sense of where the business is a little bit. Talk to your colleagues. If you're a federal judge, the Federal Judicial Center is a great resource, and we try to teach judges a lot through that resource. And then if you're on the state side, or even if you're on the federal side, the National Conference of State Courts has an amazing website for judges to learn from. Lawyers need to look to their local bar associations, but you need to include a healthy heaping, to the extent you can find it, of continuing education on AI if you feel uncomfortable with it. Use some of your CLE requirements, dedicate them to getting up to speed with this technology, and the best way to learn it is to use it yourself. You really have to try it out.
Big thank you for coming on the show, Judge Goddard. Really appreciate it.
Thank you so much for having me, Oliver. I really appreciate it.